Excuse me. Yes, Mr. Hagen.
My lord, prior to the short adjournment, my lady, Lady Justice Andrews, asked me a question, or rather she put to me, let me put it in these terms. What matters is whether James's understanding was that if Christina makes a claim, James would have to give the money back. My lady doesn't dissent from that so far as I can see. Now, what I would ask the court to do is to go back to Dargamo. So if we go, please, in the authorities bundle to, I believe it's tab 26. It's bundle 3, tab 26. And go, please, to page 911. 911. And if we focus, please, on the ratio of the Roxburgh case.
Yes.
And look at the second sentence. The majority of the Apex Court in Australia found that the basis in this case was the common intention of the parties and the revenue authorities that the cost of the goods would include the licence fees, and those licence fees, when so incurred, would be paid to the revenue authorities by Rothmans. In the events that happened, the anticipated licence fees were not incurred by Rothmans. Thus, the state of affairs, which was within the contemplation of the parties as the basis of their dealings concerning tax liability, altered. Now, the reason why I read that out is because it was not a necessary part of the basis of the transaction, objectively construed, that Rothmans needed to appreciate that if the fiscal license liability failed, they would have to account to the retailer. It was, in fact, the test is a positive one, not a negative one. The shared understanding is what premises the payment. It's not necessary to identify within that shared understanding, objectively or subjectively, an understanding that the payee will have to restore the payment if the basis fails. It's the question of identifying what sustains the payment. And my lady used the excellent metaphor of the bricks and mortar of the transaction, if I recall correctly. The bricks and mortar of this transaction were that it was simply not going to be, and it was not made, at a time when Christina would have a claim to it, as the parties thought, and that it would only be made when she would not. And that basis failed. That is a failure of basis within the four corners of the legal test. The question, there is though still a problem, which has been put to me by both my lady and my Lord Justice Nugee in writing when he ordered permission to appeal, which is to ask, but is a gift the kind of transaction that could ever attract this kind of restitutionary relief? And I accept that I've got to grip that and have a case on it. Now, the position is simply this, in my submission, that in circumstances where there is a simple payment of cash, and there is no instrument which needs to be set aside, such as a trust or a contract or anything of that sort, then one doesn't need to go through the pit and halt hoop first of setting aside a deed or such a transaction in order to claim restitution. If you could please turn up in Authorities Bundle 4, under tab 41, page 1370.
Sorry, can you get it again?
Yes, the fourth Authorities Bundle, tab 41.
Thank you.
Page 1370. And this is an extract from O'Sullivan et al. On rescission. And in paragraph 29.34, the view that was expressed in the grant of permission to appeal in this case is identified. At least I infer that this was what was being referred to. On one view, it is necessary to set aside the gift before any right to restitution can arise. But, say the authors, the civilian contract of gift is unknown to English law, and it is not obvious what exactly there is to set aside when a gift of money is made by payment. Although the contrary is well arguable, the right to be repaid should probably arise immediately. The donee's conscience is affected from the moment of receipt, and no instrument or agreement exists that is prima facie inconsistent with an obligation to make restitution. By analogy with the rule for mistaken payments, the obligation to repay should arise from the moment the sums are received. And then it said in 29.35, if this is correct, gifts of money made by conduct, and I pause to say that is what happened in this case, just a transfer from a bank account, rather than deed, are not to be assimilated within the doctrine of rescission at all. There is no need for the donor to elect to set aside the gift or to seek an order for rescission, and the bars to rescission do not apply in their ordinary form. In the eyes of the law, the transaction is ineffective from the outset, and the donor's right to enforce a claim to repayment that vested at the moment the monies were paid. And then he goes on to talk, the author's gone to talk about change of position and so on.
This is in a passage which is dealing, if you look at the previous page, with a gift of money being vitiated by fraud, misrepresentation, or vitiating cause.
Yes, I accept that.
Yes. Now, I think the thought that I had when granting permission was of a slightly different nature. It may be a completely bogus thought, but let me tell you what it is.
Yes.
Failure of basis, what used to be called failure of consideration. It's easy to see how that applies in the case of a contract, because when you pay money for something.
Yes.
And if you don't get what you pay money for, you can get it back. And that's basically it. And what the Roxburgh case shows is if you pay a single sum of money, most of which is for the tobacco, but some of which is for the licence fees, you can split the consideration. You can get back the bit that you've paid money for which has failed. But when you give someone money, you're not paying for anything at all. The gift itself is what justifies the retention. If it's a gift, it's yours. And it's not, there's no element of bargaining in it. There's no element of what you're getting in return for payment. What you're getting is the payment to court, just simpliciter. It's just a payment. So I understand entirely if you've got misrepresentation or undue influence or duress or these other vitiating factors, then this analysis is significant. But as I say, when you're dealing with failure of basis, it's not obvious to me, unless you've got a sort of true conditional gift, I'll give this to you if X.
Provided that.
And so on, which the judge rejected, I think, on the fact. It's not obvious to me that you can get a failure of basis off the ground in a case of a simple gift. Now, I may be entirely wrong about that, but that was the thought that I was trying to articulate, if that makes any sense.
Yes, my lord, if I can at least have a go at
Yes.
trying to persuade you to the contrary. The first point to note is that it is very well established that the reason why the terminology failure of consideration has been changed to failure of basis is because it was the previous terminology was apt to mislead the requirement for counter-performance promissory consideration. It's now well established that that is not correct. And so logically, there is no reason why the principles should not apply to a gift. There's just no logical reason why they should not. Once that hurdle has been dismantled, which Dargamo and other cases, I believe it's Dargamo and Barnes in the Supreme Court has established. So that is the first point. The second point is that once one has avoided that, the only relevant question then is whether its gift-like nature is a justifying factor, like a contract, which, as Roxburgh shows, isn't always a justifying factor, but is often a justifying factor, and that one needs to dispense with it first before seeing whether there's restitution reliability. And it's really that.
This point is addressing.
Yeah,
is there anything to undo?
Yes, there's nothing to undo.
Yes.
And actually the point is fortified it since we're in Dargamo. And in some ways, I would submit, in fact, I will make this submission, that it is decided by Dargamo. If we look,
Dargamo was a contract.
yes, it was. But the point that the point of law, abstract law that I'm making, was decided by Dargamo. And if one goes to 907, at paragraph 70, the concept of justifying factors has been discussed in the previous paragraph. And Lady Justice Carr says in paragraph 70, I describe this principle, namely that an unjust factor will not override a valid and subsisting legal obligation of the claimant to confer the benefit on the defendant as the obligation rule. So if one fathoms that through, it all makes the analysis in O'Sullivan actually makes a lot of sense. Because let's suppose that instead of just transferring some cash from one bank account to another, Terrell had said, right, okay, looks like the divorce is done, no risk of claims, and she took out a piece of paper and made a declaration of trust and made the gift in that way. Then there would be a legal obligation on her to hold that money on trust, and she'd have to deal with that, probably by way of some sort of vitiating factor. And likewise, had she entered into some sort of contractual arrangement, she would have to deal with that. But because this was just a simple payment of cash from one bank account to another, there isn't anything to set aside.
But that's what I'm having difficulty with, because the payment of cash by way of gift confers good legal title on the recipient. So if you ask, how can the recipient keep it? The answer is, well, because you gave it to me. I mean, that's right. So you have to find something which undermines.
Yes. So such as so you would say like a mistake or undue influence or
yes.
Yes.
Mistake of, I mean, all the regular vitiating factors: duress, misrepresentation, fraud, undue influence, payment under a mistake of fact, and all those things, which are all listed in Copinger-Symes as things which can, and one of them is failure of basis. So what I'm querying is there a basis for a gift? And it's not failure of motive.
No.
No. If I give something to you because I want to do something and my motive is later falsified, that doesn't mean I haven't given it to you. That's what I'm querying. And
yes.
What is the basis for a gift once you move away from a strictly conditional gift?
Well, that is the. It all depends on how the word conditional is used in this legal context.
Yes.
So if the word conditional is used in this legal context to mean a shared understanding upon which the transaction is premised,
then you say that you say that's enough.
That is enough.
You don't need a strictly conditional.
And there's no authority to the contrary.
Yes. Okay.
So your lordships and your ladyship, of course, can say that is just wrong as a matter of law, but it's not going to be on the basis, as we understand it, on the basis of any other decided case. It's the failure of basis. There's no logical reason why, if it can be applied to a contract as it was without vitiating the contract in Roxburgh and Rothmans, then why not a gift?
Yes, I see. Thank you.
So that is failure of basis. And I will also say, and I'm sounding like a broken record on this, the judge did not dismiss the restitution claim on the basis that gifts are a justifying factor, nor is there a respondent's notice saying that the case should be decided on another basis. And so for those reasons, irrespective of the claim in equity for rescission, the common law claim for restitution should be allowed. And I should just say, on that last point about Roxburgh and so on, about the fact that, and on the points that your lordship was making about consideration, and this goes to a point that Lord Justice Moylan was making, there was no finding in the judgment that the promises to make these gifts were in any sense enforceable. And of course, a promise to make a gift is not enforceable anymore. So that's just an observation that I make. And my very last point before I sit down is that Lady Justice Andrews said that my case is metamorphosized as to what the mistake is. I would gently take issue with that. I opened this appeal today relying upon Mr. Ham's first bullet point description, and then I matched that to finding 20 in the wife's closing submissions, and then I showed the court the transcript where Mr. Ham said, on the basis of finding 20, the mistake is not in issue. I feel that I am bound, essentially, to bring my appeal on that basis, and I will also suggest that so is my learned friend. Those are my submissions.
Thank you very much. Anything else? No. Yes, thank you very much. Mr. Warshaw.
Struggling with my chair.
Yes.
Lords and Lady. The test we suggest is actually quite simple. It can be expressed thus: is there an operative mistake so serious as to make it unjust, unfair, or unconscionable for the disposition to stand in all the circumstances? Clearly, when one articulates it in that way, there are interlinking and overlapping elements, but we submit that at its heart it's just one question. We make three fundamental points, and the first of those 3 points I'm going to do by reference to the intervener's pleading, which is in the supplemental bundle at page 83. It'll be the first supplemental bundle. Sorry, 89. I'm in the authorities bundle, give me 1 second.
Sorry, which page?
It begins, I think, at page 81.
Yes.
And if you go within that to paragraph 7 on page 82 at the foot, you'll see how this was pled.
Paragraph 7.
Paragraph 7.
Yes.
The applicant and the respondent are separated in 2017, and the respondent began financial remedy proceedings in August 17, which were ultimately disposed of by the consent order on the 4th of March 2022, and the marriage was dissolved by decree absolute on the 9th June 2022. The donors knew of those developments and at the time of the gifts believed, alternatively tacitly assumed, that all the financial claims arising out of the marriage had been disposed of. So far as the donors were concerned, the consent order settling the financial remedy proceedings was the end of the matter. They assumed that there was no possibility that the gifts would benefit the respondent. The assumption was fundamental in the sense that the donors would definitely not have contemplated making the gifts if they had thought there was any possibility that the gifts would benefit the respondents. So you can see that in the pleaded case, it was entirely plain that the restriction was to benefit. That's not the point that I'm making, but it is the point picking up my lady's point. However, what we say is that, and I will show you this in due course, that Terrell neither believed nor tacitly assumed that all financial claims arising out of the marriage had been disposed of, such that the consent order settling the financial proceedings was the end of the matter, such that there was no possibility that the gifts would benefit the respondent. We say that there is a finding to the contrary, which is why the payment of the gift was postponed in March 2022, and on any view, there was no finding that Terrell did have this belief at the relevant time in July and August 2022. And in fact, we'll see that she didn't. And on that basis, there's no mistake at all. So that's fundamental point 1, no mistake at all. The second point, if we are wrong about the first point, i.e. that there was no mistake, then there was in any event no operative mistake of sufficient seriousness to make it unjust, unfair or unconscionable for the disposition to stand in all the circumstances prevailing at the time that the gifts were made in July and August 2022. And as to this, we suggest that Terrell consciously ran the risk that the gifts might benefit the wife and or made the gifts on the basis of a misprediction as to whether the gifts might benefit the wife. Or, sorry, I won't say misprediction, I'll change that to running the risk. Now, we say that the judge made a finding to this effect, or that it's implicit from the judgment. And whilst there may be argument about that, he certainly did not find that there was an operative mistake. And the absence of such a finding, we say, is fatal to this appeal. And in this context, and in several other contexts that we'll look at, you will recall Terrell's own evidence that we looked at yesterday, the cross-examination by Mr. Todd, in which she said she would be happy for the gift to benefit her daughter to the tune of 10 million US dollars.
I'm not sure she said she
Up
would
to
be.
the sum.
I'm not sure she said she would be happy. She said it's a matter for James. Didn't she? Or did she say she'd be happy?
I'll get that right.
It's page 341. If James wanted to give Christina 10 million,
My Lord's recollection is quite correct.
my view is that James has the money, it's James's money. I do not have to ask what he does with it. I don't think she would be happy. I think she'd be very surprised.
Well, when she uses the word fantastic at page 340, she's not using that word to mean
No.
phantasm. She's meaning it that it would be a very good thing. So maybe
But that's taking her on holiday. Yes. Yes. Anyway, sorry.
My third point, evaluated objectively, it was neither unjust nor unfair nor unconscionable for the gifts to stand because, first, the manner in which the gifts were made had formed part of an artificial scheme to frustrate the family court's proper exercise of its powers. And you heard the detail of that yesterday, and I won't go into all of that again. We'll touch on some of it. There are two elements to the artifice. Conspiracy 1, which is the concerted plan to adjust the timings of payment, and Conspiracy 2, which is the plan to lie to the court to hide Conspiracy 1. Conspiracy 2 might be framed as a clean hands argument. Terrell is a claimant in equity, and she didn't approach the court with clean hands within the proceedings that led ultimately to this decision. And we would suggest that the points that I made yesterday demonstrate that she materially misled the court, abused the process, or attempted to do so. We also say that as part of the objective evaluation exercise, you have to remember the evidence that we just looked at page 340 and the preceding page about her view of money being paid by James to Christina. So that also goes to it. And we say, in assessing whether it's unjust, unfair, or unconscionable, you have to apply an objective assessment, which is set out in paragraph 128 of Pitt and Holt. And that objective exercise, we suggest, would encompass the clean hands argument. It doesn't need to be pled separately. The material was all before the court, whether it's by way of doctrine of clean hands or whether it's simply by way of a proper adjudication under paragraph 128. It's part of the circumstances that the judge could, should, and did look at. Move away from those 3 points to look at some of the detail. Looking now at the core timeline and some of the facts surrounding it. In September 2020, Terrell and Bobby decide to gift the money to James and my client's 3 siblings. Late 20, early 21, the husband knows that a substantial gift is going to be paid to him. July 21, preparations are made to pay the gifts to the 3 siblings and James. The 3 siblings are paid their money in late August 2021. James doesn't receive his gift. The judge finds that it's postponed to the conclusion of the divorce settlement. And that is dealt with at page 132 of the core bundle, at paragraph 63, Roman 4, the last 7 lines.
Sorry, can you give me that again?
Yes, it's the last 7 lines at page 132
Thank you.
of the big paragraph that would be 4. And we say that there are 2 things within this paragraph, within these lines of this paragraph. The first is that it plainly covers the intention of both James and Terrell. It is, after all, Terrell who is postponing the payment, not the husband. And importantly, the judge directly compares it with the decision in March 2022. And March 2022 is dealt with at paragraph 63, Roman 2. And that is the long paragraph that begins, "It is a troubling feature of the statements of the husband, the intervenor, Teresa, Edward, and Isabel, produced on the same day, that all of them seek expressly and specifically," etc., etc. And this paragraph is dealing with all of the family members. And so when, at the end of that paragraph, the judge makes his finding about postponement to a time that the coast is clear, he is imputing that intention to all of those characters. Going now to look at some of Terrell's evidence in the supplemental bundle. I'm going to go to page 298.
Sorry, I keep missing the. Can you give it again?
Yes, 298, my lord.
Thank you.
And we're going to start at line 6, down to 16. I say, "This is an email from you in the middle of Friday the 26th of November. It says, 'Enough is enough. We were just asking what specific details are holding up your financial settlement. James has said he is happy for you to show us the clauses which you say is obstructing the financial settlement.' You ended with, 'I'm forwarding this email chain to James. Both of you sort out the nonsense and finish it by the 16th of December 2021. Now, the reason you are so anxious for this to end is because you wanted to pay James the money, do you not?' And the reply comes, 'No, we were just fed up with it, my husband. It was really affecting him. He couldn't bear it. He was not well. My husband had kidney dysfunction. That was not what killed him.' If we go over to page 299, and go to line 19. We accepted she was getting divorced. We did not make it a bad thing for her. She could have still been part of the family even if she was divorced, but she chose not to. As soon as the order was sealed, James told you that it was sealed. He told us that yesterday, did he not?" "Yes. And you believed that when the order was sealed, it represented complete closure, did you not?" "I think so, yes. And so you didn't believe that there could be any problems in making payments to James at that point, did you?" Probably not. And so because you think the coast is clear, you send James an email. It's not the coast is clear. That is the wrong expression. Because the order has been sealed, you send James an email on the 17th of March with an offer for payment, do you not? We can see that at 3719. She says that's the same letter I sent to my other children. So this is where the language in the judgment of the coast being clear comes from. If we go to page 305, line 23. Just to, in case my lords and my lady aren't clear, this is referring to March. Then if we go to 305, line 23, we know that James defers the money, do we not? Yes, that is fine. Because he's worried about Christina's reaction. I do not know why, he just says it is fine. He just said what? Judge asked. I do not remember exactly, but it was not a problem. He wanted to defer it, that is his decision. And Judge Hess says, so when you offered 20 million, he came back to you and said, what was the broad message that he said to you about that? Not at the moment. Not at the moment. And the payment was to be deferred. So from that time onward, would it be reasonable to say that you were just waiting for him to tell you when the convenient moment would have arrived? Why? Is that right? It was not important for me to worry about it. He would let me know when he wanted it. So I carry on with that. That is not the answer to my question. Were you then just waiting for him to tell you? What happened was that my husband was not well. I had other things on my mind, and when my husband got extremely sick, and then James was diagnosed with cancer, then I said, we have to give James his money. My husband and I both said, yes, immediately, straight away. So the cancer activated the deferral. When we found he had cancer, we organised as quickly as possible to get him some money, yes. I think Edward said this morning that your husband became very unwell at the end of 2022. He was in hospital at the end of June, and I brought him home because it was during COVID and we could not visit. One person at a time was allowed to visit. They had security coming and taking us out of the hospital. It was just terrible. It was a terrible time, and so we were trained in how to give him his medication. I brought him home and had nursing at home, and we were all with him all the time at home with all the family. It was a terrible, terrible time, the worst week of my life. So this illustrates what the judge was deciding. He was deciding that in March 2022, Terrell knew that the sealing of the order was not enough to ensure that there was no possibility that the gifts would benefit the respondent. She was waiting for a signal from James that the coast was clear. There never was any such signal. Instead, in July and August, on Terrell's own evidence, she decided to take the risk and concluded, which is at line 24 and 25 of 306. What happened then was my husband was not well, I had other things on my mind, and when my husband got extremely sick, and then James was diagnosed with cancer, then I said, we have to give James this money. My husband and I both said yes, immediately, straight away. And if you go forward, you'll see further confirmation of this at page 309.
I thought that evidence was rejected.
No, my lady. What the judge rejects is the cause of the payment being the cancer, rather than the timing of the payment.
Yeah. Or the timing of the decision to make it, rather.
Yes. And if you go forward to 309, starting with line 1, that is because, and she's referring to the letter that was sent at the time, that is because it was, you see, the last part is all from the other letter I sent to the children. She's talking about the similarities between the letter sent to the husband and the letter that had been sent to the other children in July 2021. That is why I would have taken that. And because of the situation at the time, I was not completely with it myself as far as the computer goes. It was the least of my problems, but I wanted to make sure that James was looked after. My husband and I were both very upset about him having cancer after having been through everything else. Did you draft this letter after Bob had passed? No way. Why would I do that? I gave the letter to James beforehand. James arrived the day after Bob died. The letter was written on the 5th of July. I would not have made that up. Obviously, Bob had expressed the sentiment, of course. But might not you have created this just to give some extra force to the sentiment? No, I'm not like that. Why did you have to sign it for him? I signed it for him because he was very sick. I'd often signed things for him before. So he was too sick to be involved in the drafting of this, not. And then, yes, he knew, but we knew what we wanted to do because I had already done the other letters. You see, the bottom half of the letter is the same letter I sent to my other children. So why now for this? Asks the judge. Pardon? And the judge says, why do you need to do this in such a hurry when your husband is very ill? It must have been a terrible time for you. Why do you even need to write this? Because we had just heard James had cancer, and we wanted James to have the benefit of what we had given the other children. You wanted James to have the benefit of this letter, did you not? And then if you go forward to page 315, I'll start, if I may, at line 314.23. You're offering him the same payment in July that you offered him in March. Yes, that bit is right. And you are connecting it to the cancer to mislead, are you not? No, no, no. The cancer was what made us give it to him sooner. That is the reason to end the delay. It's not the reason for the payment. The answer agreeing with that is no. So there the witness is agreeing that it was the reason to end the delay, not the reason for the payment. And this then is confirmed in cross-examination by Mr. Todd at page 345. At line 11, yes, in August of 2021, when you were making gifts to your other children, i.e. not Christina, did you know anything about if you gave money to James it might impact on the case or anything of that sort?
I'm sorry, which page?
This is 345, line 11.
Thank you. Thank you.
So I was just reading from line 11. I'll pick up line 15, the answer to the question. I thought there might be, but I do not know. Did you have a conversation with James along the lines of, I would like to give you some money, but I cannot because I appreciate you're in the middle of the divorce? I do not think that I had that conversation with him. I cannot remember exactly. If in March of 2022 it had been told to you that if you give a large sum of money to James, then it's going to result in this sort of litigation and Christina might get a share, would you make that gift? I would not have made a gift at that time if Christina was getting any, correct? When James said, well, this might cause a drama if a payment is made at that time, did you explore with him further what a drama was, or just accept it probably would cause a drama? No, I listened to what he said. So you accept that in March 2022? Obviously, yes. So before you did what you did in July 2022, did you ask him? No, I did not. Hang on, I haven't asked the question yet. I'm sorry. Did you ask him, will this still cause a drama, or has time passed? Did you ask him that question? No, I did not ask, because my husband and I just wanted to make his life easier, because we had had a number of friends who died from cancer pretty horribly, and James's father also. So the possibility of a drama was put out of your mind because of the cancer. Of course, that was more important to us. So, if you turn to, and in fact the very closing submissions that Mr. Hagen made to you already, but if that's best seen at page 38 of the core bundle. And look at paragraph 4 of the intervenor skeleton. It's difficult to see how paragraph 4, there was no real dispute at trial that the intervenor would not have made the payments but for her belief that the wife was unable to rely on them to reopen the financial remedy proceedings. How that can be said. And we'll see some more material about this in a moment. Likewise, at paragraph 14 at page 42. The judge did not make further detailed findings about the state of mind of the intervenor or her husband in making the gifts. However, he appeared to accept, in dealing with the mistake claim of paragraph 81, the intervenor's submissions that she positively believed, or at least tacitly assumed, that the divorce proceedings had been concluded, such that the wife could make no further claims that this belief was mistaken, and that it was an important factor in making the gift. We looked yesterday, and we probably don't need to go there again, we've only looked at it, I think, in the last 10 minutes or so, at the part of the evidence relating to the payments that might be made by James to Christina, which are at, for your note, supplemental bundle 339, 340, and then Mr. Todd's at 341. How is that evidence to be fit into the appeal before you? We say that it can't be. Likewise, if one looks properly at Mr. Ham in closing, we can see that it can't possibly be said that mistake wasn't an issue. We go in the supplemental bundle to 552. We start at
552.
552, and we're starting at letter H at the bottom. Mr. Ham's iPad is misbehaving. Judge Hess says, I can read it. It's all right because I can read it. So, then he quotes, mere ignorance, even if causative, is insufficient. But the court, in carrying out its task of finding the facts, should not shrink from drawing the inference of conscious belief or tacit assumption where there's evidence to support such an inference. So what does that mean, Mr. Ham? It means, Judge Hess intervenes, mere ignorance is not sufficient. So here we're talking about the assertion that she is, Mr. Ham says, ignorant to the fact that her payment might open up a claim for the wife to get some, presumably, provision. Yes, ignorance of the fact that the wife may be able to reopen her claim. So ignorance, even if causative is insufficient. No, she didn't know that, but the correct analysis is that, as a fact, it should be found that she assumed that the... I see so. So not mere ignorance of the fact, but actually a positive belief that she was safe to make the payment. Is that right? Either a positive belief or a tacit assumption. Positive belief, I believe, you would have to have formed some particular proposition in her mind. But then here it is either. So in this case, of course, she was told in March, this is all very difficult at the moment. Don't give it to me at the moment. No, she was told March 22 that it was difficult, but she believed that once, the word that she used, I think, was finalised. Once the divorce was finalised, it was assumed. No. After she was told it was finalised, yes, she offered the money, and then she said that might be difficult. She might do something difficult. Yes. So she said, okay, we'll hold off. Let me know when it's safe. Yes, but then he got cancer, and she decided to give him the money anyway. That is what was said anyway, yes. Well, that's a question about whether after he got cancer, he broke the causal link. That broke the causal link from her misapprehension to use her mistake. Right, so she was not ignorant of the possibility that giving money shortly after an order was made might cause a difficulty. Might cause a difficulty, but she decided to take a chance on it. Would not that be an inference from what happened? No, I wouldn't accept that it's the right inference to draw. If she had consciously said, I'm going to run the risk of this, then that would be a bar to the mistake claim. But there's no evidence that she did. They went ahead and made the gift. But if they had not believed that there had been nothing to disturb the belief, which my learned friend invites you to find, and I'm going to come to that finding point in due course, that after the finalisation of the divorce, well, she was told after what she thought of the finalisation of the divorce, query this question about sealing, but after, well, let's not debate that. After everyone thought it was all over, she was told it was all over. She said, okay, in that case, I can now give you this money. And he said, well, hang on a minute, that might create a difficulty. Let's hold off. And I think she told me, look, let me know when you want it. It might create a difficulty, but that did not dispel her belief that the finalisation of the divorce was an end to the possibility of a legal claim. It was done directed to the practicalities that Christina might make trouble and that it's something different from the belief or tacit assumption upon which we rely. But in any event, we are not talking about the sole cause here. We're talking, I think, about the mistake having a causative effect, and that, we say, is certainly the case. If she'd been told, no, you're quite wrong, it's not finalised, she would have gone ahead. Would not have gone ahead. How can it be said in this appeal that mistake was not an issue? How can it be said, if looking at 55F, where Judge Hess says to Mr. Ham, so tell me, Mr. Warshaw has suggested...
Sorry, 55F.
Sorry, 555.
555.
Do apologise. So tell me, Mr. Warshaw has suggested that I should attach importance to the fact that your client, and indeed the siblings also, suppressed or certainly did not mention the fact of the March 2022 loan in their statements of July 2023. So what should I make of that? No relevance to the position. No relevance. No as to the setting aside of gifts. Is it relevant to the unconscionability? Or would you say not? No, not relevant at all. Not relevant. Or, well, if you put it into the mix, it's certainly not determinative. Can I pick out some of the points that Mr. Warshaw has made? Yes, of course, yes. Mr. Warshaw repeatedly criticised my client's failures in disclosure, and in particular referred to the failure to disclose written communications with Edward. But the evidence from Edward was about the July transfer of 45 million. But Edward's evidence was that this is something he had discussed with his mother. The fact that people are capable of using emails and WhatsApp and other means of communication, it doesn't mean they don't speak to one another once in a while. Well, they will talk in the old-fashioned way, yes. Yes, there was complaint about failure to disclose emails between Edward and Teresa, exchanging the Excel spreadsheet in the original form as opposed to the PDF. But what came to my client was the spreadsheet with the attached PDF. Sorry, it was an email attaching the PDFs of the spreadsheet. It goes on with the detail about that. How can it be said that the issue may not have been labelled clean hands, but how can it be said that the issue wasn't raised? The judge himself is raising it with Mr. Ham. And now we go to what we suggest is a very awkward presentation of the way in which we put the case in closing. If you could turn in the supplemental page to page 650. We set out a series of findings that were sought. And Terrell, in her skeleton, picks findings which help her and ignores findings which completely blow the point out of the water, as I will show you. Finding at number 10, the family maintained a ledger of outstanding loans. Teresa was the custodian of the ledger. It was a live document which had existed for many years. Finding 11, Edward arranged the transfer of 45 million US into 60.9 million Australian in July 21. The transfer was made on the basis that this sum would meet payments to Edward, Isabel, Teresa and the husband. Then we drop down to the bottom, 14. Finding. Australian dollars 20 million was paid to the wife's siblings in August 2021. The payment to the husband was agreed with the husband to be withheld pending the conclusion of the financial remedy proceedings. The intention to pay the husband was withheld from the wife. Overleaf at number 15. Finding. The unredacted bank statements concealed by the wife's family show that after payment to the wife's siblings, the wife's parents' account held 19.6 million Australian dollars. The sum offered to offered to him in March 2022 was 19.544 million Australian dollars. Finding. The family have suppressed. Finding. The family have suppressed information and disclosure about the August 2021 payments and the lead up to the August 2021 payments. Of course, that is part of the what might be called the clean hands argument. 17, although all of this is. Finding. Australian dollars 20 million was paid to the wife, and 20,000 was paid to the wife and the husband's children in August 2021. There were several conversations with the husband about the payments to his children. He was aware of the context. Then at page 653, finding 19. The husband was sharing information from the financial remedy proceedings with the wife's family. The family was sharing the wife's emails to them with the husband. Finding 20. This is one of the ones that Terrell relies upon. The wife's family and the husband mistakenly believed that upon the financial remedy order being sealed, the wife would have no claim against the husband. Stand by that finding. As you'll see in due course, we modify it. 21. Finding. The family and the husband were encouraging the wife to bring an end to the proceedings so that they could make the payment to the husband. March 2022. 23. Prior to the March 2022 hearing, he did not disclose to the wife or the court that he was aware that he was due to receive 20 million Australian dollars and a further as yet unquantified sum relating to the Singapore litigation. 24. This is one of the findings that is picked out. The wife's mother and the husband mistakenly believed that upon the financial remedy order being sealed, the wife would have no claim against the husband. Again, we have no problem with that finding. The problem that we have is taking finding 20 and 24 and not looking at the other findings. Then if you go forward to page 654, finding 26, upon receipt of the sealed order, the husband immediately informed the wife's family. The wife's mother then offered 20 million to the husband. The wife's siblings were all CC'd and were aware of the offer. 27. Finding. After 25th of March 2022, the husband understood that the receipt of the monies so soon after March 2022 would enable the wife to bring an application, that she would be able to cause trouble. It was agreed by the husband and the wife's family, that includes Terrell, that the monies would be deferred on the basis of the new information. Finding. the husband and the wife's family took a decision to conceal the March 2022 offer within these proceedings. And then at 655, finding at 30, in July 2022, following the husband's cancer diagnosis, the family decided to bring forward the payment of 20 million Australian dollars and made the payment to the husband. Finding, the husband and the wife's family sought to connect the payment to the husband in July 2022 to his cancer diagnosis and to decouple the connection between the husband's July 2022 payment and the March 2022 offer and the August 2021 payment to the wife's siblings. 32. Finding, the husband sought to suppress disclosure of his receipt of 20 million Australian dollars in these proceedings. 33. Finding, the husband and the wife's family, having agreed to defer the August 2021 payment, underwrote that decision, tagging the exchange rate to July 2021, which benefited husband to the tune of 1.179 million US dollars. Now, if you look at page 40 of the core bundle, this is the intervenor skeleton argument.
Yes.
Paragraph 13, a chronology is set out, breaking down all the steps. And if you go to that chronology, into that chronology to K, you will see the consent order having been approved on the 4th of March 2022, was sealed on the 18th of March 2022. Decree absolute was ordered on the 9th of June 2022. Then rather awkwardly, the next entry is the payment in July 2022 of the 14.77 million. There is no mention in this chronology of what happened in March. But even more importantly than the failure to mention that is at paragraph 15, where it is asserted that the findings lead to the judge, to the ineluctable conclusion that the judge was faced with agreement that there was a mistake, miss out the findings about what the husband discovered in March 2022 after the sealing of the order. And the family's involvement in that. So we looked at that finding a moment ago. It's the finding at it's the finding 27. And 28, which is at page 654.
Those are findings you asked the judge to make. How many of them did he actually make?
Well, I can go through each of them and tell you which ones in particular, but he certainly made that finding, the finding that was missed out. So there was no mistake. The intervener knew that there was a risk of the wife causing trouble after the order was sealed in March 2022. And I pause to say, because this, my Lord Justice Nugee speculated the hypothetical discussion that one might have with a matrimonial solicitor about this. And the hypothesis was on the basis that a clean breast was made to that solicitor. But I would say it might be helpful to consider for a moment what would happen if, rather than a clean breast were made, the fake story were given to a matrimonial solicitor at that point. My son-in-law has just finalised his divorce from my daughter. I have fallen out with my daughter and I wish to give a very large sum of money, which dwarfs the matrimonial estate. I wish to give that to my son. Not, I've always intended to do that, but I wish to do that now. What would the hypothetical solicitor in that hypothetical situation say? She'd look up the case of Barda and remind herself of the law surrounding Barda and say, well, if you haven't yet determined that, it would probably be best to leave that for 12 months. And to comment on the point about the fact that the point that I was making was that the intervener knew that there was a risk of trouble after the order had been sealed. By making those gifts in July and August 2022, she assumed the risk. And so, contrary to the pleaded case, there is no mistake. And we say that the judge makes the necessary findings that there was no mistake. The husband and the family all know that the July payment and the March payment are deferred because the wife could cause trouble, and no signal was ever given that the coast was clear. If we're wrong, it's incontrovertible that he didn't make any findings that he had to for her claim to succeed. But I just want to turn to, in the core bundle, page 137. The points in the judgment that are set out by the judge, the 4 bullets that Terrell must establish. Bullet 1, she believed the divorce proceedings were concluded so that any gifts she made to James could not be claimed by Christina. Terrell confirmed this in cross-examination. That's simply a complete misrepresentation of the cross-examination. And it doesn't fit with the finding that the judge made at page 131 in the last section of Roman 2 at the top. The husband told me about a week later he decided not to accept the gift. No emails or messages he sent to explain this change of mind have been disclosed. Apparently there were emails, but they've been deleted. It was not clear from the oral evidence before me. It was clear from the oral evidence before me that the dominant motive at the time was a fear that the wife would cause trouble when she found out about the gift, i.e. seek to set aside the consent order exactly what she's done, and that it was a question of postponing the gift to a time when the coast was clear, not cancelling it altogether. And this is part of the deliberate conspiracy made by all 5 of them, and that is dealt with at an earlier part of the same paragraph, 6 lines down from the beginning of 2. I've no doubt that all 5 of them. The second bullet, sorry, I'm going back now, sorry to dart around in this way, I'm going back to 137. That belief was a relevant cause of Terrell's decision to make the gifts to James. Again, this was confirmed in cross-examination. Terrell also emphasised that James' cancer diagnosis in July 2022 was an important factor, but it was clear that Bob and Terrell were only thinking of making a gift after March 2022 because they understood the divorce was concluded and Christina could not benefit. That's simply wrong. We've looked at the evidence about that, but the judge didn't make findings sought as to Terrell's thought processes on causation, and even as Mr. Ham was forced to acknowledge the real driver behind the timing of the payment of the gift was James's cancer diagnosis. And as a result, adopting Sir Terence Etherton's words, Terrell deliberately ran the risk, or must be taken to have deliberately run the risk that she was wrong. From the bullets above. The third bullet. That belief was mistaken. This will be established if Christina succeeds on her application. The asserted belief, i.e. that they were only thinking of making a gift after March 2022 because they understood the divorce was concluded and Christina couldn't benefit, was specifically found to be wrong and to be part of a dishonest account of the fraudulent scheme. Now, what Mr. Hagen says is that when you read paragraph 81, it's implicit that the judge is accepting 1, 2 and 3. And what my Lord Justice Nugee said was, well, perhaps what he was doing was saying, I've actually found those, so now I'm just going to look at what would happen about the unconscionability test. And we say that that is very much fortified by the fact that he had made the critical finding, not just in the paragraphs we looked at, but in the section dealing with the intervenor's application. The structure of the judgment, if you turn to page 134. We have a title, the intervenor's application. And paragraph 69, to 74 are the headpiece. If you turn to 75, Mr. Ham has, however, presented his case on 2 bases, failure of basis and mistake. Paragraphs 69 to 74 are a headpiece to both heads put forward by Terrell. And if you look at paragraph 73, and remember that this is not just about failure of basis, Mr. Hagen was suggesting to you. It's also about mistake. He makes a critical finding at 73. It is entirely clear to me that the gifts made to the husband were intended to be outright gifts. '74, on the face of it.
Outright as opposed to conditional.
Well, he then deals with condition at 74 specifically.
Well, I'm just trying to think what else could outright mean.
If there were any doubt at 74, he clarifies it.
Yeah.
Because he tells us on the face of it, there's no sense here of any condition
on
the gift. The money once given is the husband to do as he wishes. Now that applies just as much to failure of basis as it does to mistake. That's why he's already said there's no mistake here because there was no condition. That is why he does exactly what my Lord Lord Justice...
Is that right as a matter of analysis? Is that really quite right? I can intend to make an unconditional payment to somebody. It doesn't stop me being mistaken.
But the condition is that none of it will go to Christina. And if there is no such condition, there's no such mistake.
Yeah, well, that I do get.
So that's why he's able to do that. He doesn't use the judge's flourish that he should be using at the point in paragraph 81 where he says, I'm rejecting 1, 2, 3 in, 1, 2 and 3, just in case the case ends up here, I will then cover off the very last base. He covers off the very last base because, frankly, it's relatively familiar territory. He's got to apply paragraph 128, which is to look at, so if the 4th bullet says the mistake was sufficiently grave to make it unconscionable for James to retain the gifts, with the result that Christina is able to share in those gifts. This is made out, it would be a serious matter for the court effectively to force Terrell to share a part of her wealth with her daughter in circumstances where she's made it as clear as she possibly can that it's not her wish to do so. Right? And what the judge had before him, and he's bearing in mind in paragraph 81, he's seen the mother's evidence that the husband could do whatever he liked with the money. He doesn't recite all that evidence, but he tells us about it. He's not telling us only about the letter, which my lady rightly said is a contemporaneous record of intention, but he also had the oral evidence. He doesn't need to refer to that, but he's referring to the complete evidence, the totality of the evidence. There were no restrictions on the money. And he had seen the evidence. We can see that in the dialogue that he has with Mr. Ham, that it was Carol's evidence that she wanted to get the money to James as soon as he was diagnosed with cancer. And essentially, she throws caution to the wind and accepted the risk that our Christina might somehow benefit. We'd also seen, under questioning from the judge, we've also seen Terrell's evidence that she was never given any signal that the coast was clear. So, whether Judge Hess could have written a longer paragraph, no doubt that criticism could be made of almost any judgment, that longer paragraphs could be written. But what he did was to evaluate objectively. And of course, at the forefront of his mind is everything that he set out in paragraph 63. When he's thinking about unconscionability, he's thinking about the fact that the gifts had formed part of an artificial scheme to frustrate the proper exercise of the family court's powers. You heard all that yesterday in detail. And we may not have said it at the time, but this is a claimant in equity. And the idea that you can tease out two separate cases, Terrell was lying in both cases. And we say that the judge's approach was completely consistent with that mandated by Lord Walker in Pitt and Holt, when you take the judgment together compendiously, which you must. Now, I'm going to turn to the law, and Mr. Cumming would like me to spend a very long time on this, but I'm not going to. I'm going to look at paragraph 128, which is at page 406 of Pitt.
Can you remind me which?
It's in, yes, 128. 406 would fall in bundle 2. More generally, the apparent suggestion that the court ought not to form a view about the merits of a claim seemed to me to go wide of the mark. In a passage in Gillett and Holt, since approved by the House of Lords, see especially the speech of Lord Newberger, I said in discussing proprietary estoppel that although its elements, assurance, reliance and detriment, may have to be considered separately, they cannot be treated as watertight compartments. The fundamental principle that equity is concerned to prevent unconscionable conduct permeates all the elements of the doctrine. In the end, the court must look at the matter in the round. In my opinion, the same is true of the equitable doctrine of mistake. The court cannot decide the issue of what is unconscionable by an elaborate set of rules. It must consider in the round the existence of a distinct mistake as compared with total ignorance or disappointed expectations, its degree of centrality to the transaction in question, and the seriousness of its consequences, and make an evaluative judgment whether it would be unconscionable or unjust to leave the mistake uncorrected. The court may and must form a judgment about the justice of the case. And we say what Mr. Hagen is inviting you to do is to consider this in watertight compartments and by reference to an elaborate set of rules. You're being invited to tear up Pitt and Holt. And we say, I've already said this, that the judge's approach to his exercise in paragraph 81 and the rest of his judgment was entirely consistent with paragraph 81. A criticism is made about the way in which the judge articulates the interrelationship between the family court and the Matrimonial Causes Act claim and the gift. And it's quite clear that there is a species, regardless of, or as part of the exercise of 128, there is a species of mistake. Not that there is a mistake, but if there were a mistake, there is a species of mistake which fall outside the pit and or within the confines of pit and hall. Those are the forms of mistake that should not attract relief. They're dealt with on page 407 and 408, paragraph 132 and 135. Paragraph, I would therefore reject the first new point as much too wide and unsupported by principle or authority. But it is still necessary to consider whether there are some types of mistake about tax which should not attract relief. Tax mitigation or tax avoidance was the motive behind almost all of the Hastings-Bass cases that were concerned with family trusts as opposed to pension trusts. In Gibbon and Mitchell, there was a mistake as to the legal effect of the transaction, which was to plunge the family into the trap of forfeiture under the protective trusts, rather than to achieve the immediate acceleration of the adult children's interests. But the seriousness of the consequences of the mistake was greatly enhanced by the inheritance tax implications. On the test proposed above, consequences, including tax consequences, are relevant to the gravity of a mistake, whether or not they are, in Lord Justice Lloyd's phrase, basic to the transaction. And then if you go ahead to 135, in Futter, this court declined to permit the appellants to raise for the first time the issue of mistake, primarily because there was no sufficient evidential basis for considering that issue for the first time on a second appeal. Gibbon and Mitchell received a passing mention in the judgment of Mr. Justice Norris, but only for the purposes of rejecting the revenues argument that the distinction between effect and consequences was relevant to the Hastings-Bass rule. Had mistake been raised in Futter, there would have been an issue of some importance as to whether the court should assist in extricating claimants from a tax avoidance scheme which had gone wrong. The scheme adopted by Mr. Futter was by no means at the extreme of artificiality. Compare, for instance, that in Abacus Trust, but it was hard. Compare, for instance, that in Abacus Trust, but it was hardly an exercise in good citizenship. In some cases of artificial tax avoidance, the court might think it right to refuse relief, either on the ground that such claimants, acting on supposedly expert advice, must be taken to have accepted the risk that the scheme would prove ineffective, or on the ground that discretionary relief should be refused on the grounds of public policy. Since the seminal decision of the House of Lords in Ramsey, there has been an increasingly strong and general recognition that artificial tax avoidance is a social evil which puts an unfair burden on the shoulders of those who do not adopt such measures. But it is unnecessary to consider that further on these appeals. That issue is then dealt with by decision in this court in Bauer, and we say that it is, in all material respects, the way in which it's dealt with in Bauer, the way in which you should approach the artificial scheme that had been created by the conspirators in this case. Which page is it? Yeah. Volume 4, 1091. I'm going to go within this judgment to paragraph 75, 1111. Paragraph 75. In the time since Lord Walker identified the use of an artificial tax avoidance scheme as a possible basis for the refusal of equitable relief, the point has been considered in several cases. Two mention merit. In Vandermeer and Goldman, Mr. Justice Morgan granted equitable relief on the grounds of mistake in relation to an inheritance tax scheme and found on the facts that the parties involved had not been engaged in artificial tax avoidance. More recently, Ducary's Healthcare Deputy Master Marsh held that on the facts there was insufficient evidence as to the states of minds of the relevant persons at the claimant company to justify setting aside a disposal on the grounds of mistake, but that in any event relief should be refused because the disposal in question to what was described as a remuneration trust was an artificial tax avoidance scheme. The Deputy Master referred to 10 factual matters concerning the design and operation of the scheme upon which the revenue had relied to demonstrate that the scheme was artificial. These included the fact that although the scheme involved the use of what were described as remuneration trusts, all of the past and present employees of the applicant company were excluded from benefit. And then if you advance to page 1115, and so at 101 we get a brief reference to the facts. This, however, was a case in which Mr. and Mrs. Barr deliberately chose to implement what they knew to be a tax avoidance scheme, which to their knowledge carried a risk of failure and possible adverse consequences. Their mistake was to think that those adverse consequences could be avoided by the reversal of the transaction and the reclaim of the fees paid to Aston Court under the fee guarantee. And then at 102, it also seems to me to be of considerable weight that the scheme was, on any objective view of the facts, an entirely artificial tax avoidance scheme. And then if you go over leaf to 104, first sentence, I'm trying to do this quickly. It is, in the circumstances, difficult to imagine a more artificial construct than the first staff remuneration trust established under the scheme. Then at 105, I fully accept that tax avoidance is not unlawful, but I agree with Lord Walker's observations in Pitt and Holt that artificial tax avoidance is a social evil that puts an unfair burden on the shoulders of those who do not adopt such measures. In my view, this is a very weighty factor against the grant of any relief. Taken together, I am firmly of the view, even on the basis that the appellants were not complicit in the dishonesty of Aston Court, it would not be unjust or unconscionable to refuse equitable relief and to leave the consequences of the appellant's mistaken belief uncorrected. Now that, of course, is a case of mistake, and we say you don't even have to get to that because there's no mistake here. But if there is a mistake, it's not one to which equitable relief should attach. Turning to the wife's appeal, the intervenor's appeal skeleton at core bundle, page 44. Mistake. It's asserted that there was no dispute, that the intervenor positively formed a mistaken belief. And we say there was a dispute, as we've shown you, as to whether at the time of the gifts the mother had positively held a mistaken belief. There was a dispute about that. And moreover, we say the judge didn't accept that was the case. Paragraph 20b, even if it had been in dispute, there clearly was a mistake. We say this paragraph completely overlooks that the judge found that the mother's perspective evolved along with the husband's perspective in March 2022, when upon the payment being offered, the husband asked for it to be postponed as the coast was not clear. Paragraph 21 deals with causation. Yeah, it said that there was no dispute that the mistake was causative in the but-for sense. Similarly, we say there was a dispute as to whether any alleged mistake was causative, and there's nothing in the material before you which demonstrates or suggests otherwise, other than assertions made on behalf of Terrell. Regardless, and in any event, the alleged mistake was not causative. It's quite clear from the exchanges regarding the cancer diagnosis between Mr. Han and the judge. There was no finding that it was causative, and one couldn't properly have been made out on the evidence. The suggestion at paragraph 21C that it was the intervener's unchallenged evidence is completely contradicted by the extracts we've shown you. She knew about the problem. The problem had been raised with her by the husband, but she decided to make the payment because of the cancer diagnosis. Paragraph 22 deals with seriousness. The assertion that this is incontrovertible about the desire to exclude the wife from benefiting from the wealth does not fit comfortably with the transcript that ends at page 340 with Mr. Todd's cross-examination. And this ground blurs into all the others, consistent, we say, with the approach, which is that this is actually a very simple test. And there's no finding that the mistake was sufficiently serious, and that's because there's no finding of a mistake. Certainly, if there were a mistake at the time of the gift, the mistake was not sufficiently serious, having regard to all the circumstances, including the role played by the cancer diagnosis, the extent to which the intervener was a conscious risk taker at that point, the fact that she appears, but we don't know, she hasn't come with an open book, as Mrs. Pitt did. Appears that she took no advice of her own about the point, still gave the gift. And then the evidence, again, the evidence I've already mentioned about the dinners, etc., the holidays, and the $10 million.
Was there evidence that she did, positive evidence that she did not take advice, or was there just no evidence at all?
There's no evidence. But and perhaps in the cases where equitable relief is granted for mistake, these are cases where people come with open books. This person gave me the wrong advice. There are no cases, even in Bauer, there are no cases where people are hiding behind disclosure. There are findings that emails have been destroyed and not deleted emails. And they're going both ways. When the husband sends an email that he says has been deleted that deals with this topic, and then the intervener's ordered to produce those emails and she doesn't produce them, then she must have deleted them too, or not provided them as part of the exercise of disclosure. It's just tortuous to think that equity should come to the relief of a person in Terrell's shoes. Paragraph 23, fairness and unconscionability. The way that the case is put here is an attempt to rewrite paragraph 128 of Pitt and Holt. You cannot squeeze 23b into the four walls of paragraph 128. If you go to 23e, it is not in any event for the court to approve or disapprove of the intervener's motives, unless they amount to illegal, improper, or inequitable conduct, which might lead the court to deny relief in the exercise of its discretion. Well, we say the judge did form a view correctly that Terrell's behaviour was improper and inequitable. As to the clean hands point, again, I think I've made this a number of times. We say whether it's under the very specific equitable concept of clean hands or whether it's under paragraph 128, the judge took it into account. Of course he did. It was inevitable that he was going to take that behaviour into account. It's difficult to imagine worse litigation conduct. Double litigation conduct, as I said, it's this double conspiracy. The conspiracy to hide the gift from the court in the first proceedings, and then the conspiracy to hide the truth about the gift in the proceedings. If this is not a lady who has come to court without clean hands, it's difficult to imagine who might be able to come to court without clean hands. And if I do struggle, and perhaps this is pushing it an open door, but I do struggle with the notion that because my client has asserted rights in equity in New South Wales, that puts her into the same position as someone who has come to court deliberately determined to lie. On the core issues. How? Is that really an equitable principle? That you can weigh up someone pursuing a right in a foreign jurisdiction against someone who has attempted to pervert the course of justice? The conclusion on the question of mistake. The intervener failed to get the highly fact-sensitive findings that she needed at trial. And what she has done is to try to mask that by suggesting it was common ground that there was a mistake. It wasn't common ground. That's fatal to the appeal. In any event, if, as here, a donor pays a gift knowing that there's a risk that my client might cause trouble, which is why the payment was delayed, and the donor later pays the gift anyway, without the coast is clear signal being given, then the donor hasn't given the gift operating under a mistake sufficiently serious to merit setting aside the gift subsequently. And stepping back from all of this, how can it possibly be said to be unconscionable to allow the gift to stand in the circumstances of this case with the background of the conspiracy that I described to you yesterday? I think I can deal very quickly with failure of basis. If you go in the supplemental bundle to page 8, no, am I going to the wrong place? 83, sorry. Apologies, it's page 83. Paragraph 8. Call bundle 83, my lord.
Yes.
In the premises, this is the pleading put in by Terrell. In the premises, the benefits conferred on the applicant by the gifts were conferred on a joint understanding that the applicant's right to retain was conditional, and that if the condition was not fulfilled, the applicant must, subject to any available defence, return the gifts. The condition was the respondent was not to benefit from or as a result of the gifts. This was so obvious to the donors and the applicant that it went without saying. Well, really the start and the end of this, and I'm not going to go much further than this, the start and the end of this is the judgment at page 134 core bundle. Paragraph 73. We've been here before. It's entirely clear to me that the gifts made to the husband were intended to be outright gifts. And he quotes the letter. And then at the end of the letter, paragraph 74, on the face of it, there is no sense here of any condition on the gift. The money once given is the husband's to do with as he wishes. That's his finding. It's not just based on that letter, that contemporaneous evidence. It's based on the evidence that he's heard. And you can't begin to get any legs on failure of basis in circumstances where the judge has made a perfectly proper finding that the gift came with no condition. We talk about interesting cases for hours, but they have no relevance to the facts at bar. The appeal should be dismissed.
Yes, Mr. Hargan.
My lords, my lady, let me deal first with this proposition that there was a finding by the judge that Terrell consciously took a risk in and after March 2022. Now, my learned friend's case theory, which he has put forward, is that the judge's rejection of my client's evidence in relation to the significance of the cancer diagnosis was only a timing point which prompted the making of the gift when it was made. But what the judge actually found, if we can just bring it up, please, which is at page 131, the judgment, core bundle.
Yes.
Yes. If one just, yes, it's 63.2. Apologies. In 63.2, about 7 lines down, I have no doubt that all 5 of them were well aware that exactly the same gift had been expressly offered in writing in March 2022, well before any thoughts that the husband might have cancer, and was in reality not linked to his cancer diagnosis at all. Not linked at all. The question was not put to my client that she consciously took a risk. And there was much criticism of my client's, for the presentation on her behalf in her skeleton argument. But what my learned friends did not do was take you to our supplemental skeleton argument, which dealt with this very point. So if we can look, please, in the supplemental, in the core bundle at page 70. You will see that we went to that finding 27, which my learned friend said essentially changed everything. The one that he said meant that somehow the invitation that the court make a finding that there was a mistake wasn't an invitation that the court make a finding that there was a mistake. And what it said, finding 27, was after 25th of March 2022, H understood that receipt of the money so soon after the March 2022 order would enable W to bring an application that she would be able to cause trouble. Full stop. It was agreed by H and W's family that the monies would be deferred. The wife did not invite the court to make any finding that the intervener shared that understanding, nor did the wife invite any findings about the intervener's state of mind in the section headed mistake. So like my learned friend, I do invite the court to spend a bit of time with the written closing submissions put forward on behalf of the wife. And you can read them as many times as you want, but you will not find any invitation in there by the wife that the court should have found that the wife, that the Terrell was a conscious risk taker in and after March 2022. The passage that my learned friend took the court to in the oral exchanges during the closing submissions were between the judge and Mr. Ham. So what Mr. Ham had done was he'd said, the mistake point doesn't seem to be an issue. And then there's a bit of debate between the bench and counsel about that point. The judge records in his judgment that conscious risk-taking is an issue in a Pittenholt case. We've seen that on page 137 of the bundle, as I recall, when he records Mr. Ham's submissions. And having recorded that that was something which he needed to consider, he then doesn't make any findings about it at all. And what I would just invite the court to do is to go back and look at the finding which the wife asked the court to make. It is unambiguous. In fact, it was so unambiguous, she asked for it twice. Now, it is true that the judge did make a finding that the husband deferred the gift in March 2022. There's no doubt about that. But the wife said in cross-examination that she didn't know why that was the case.
The mother.
Sorry, the mother.
Yeah.
And it may be that my learned friend thinks that's implausible, but it wasn't said, no, that's not true, is it, Mrs. de la Sala? And then finding 27 is then drafted. H and I understood that receipt of the money so soon after the March 2022 order would enable W to bring an application. And my learned friend was absolutely fair in his closing submissions in restraining that to H, because it wouldn't have been fair to impugn my client's evidence if it wasn't tested in the way that it should have done on that point. And therefore, when you read the finding that the cancer diagnosis evidence had no link at all to the July 22 gift, with the findings which the judge was asked to make by Mr. Ham and by Mr. Warshaw, and then you link that to the fact that the judge did not make any findings about risk-taking, the idea that this is a case where risk-taking was at the heart of some sort of implicit rejection of the mistake case is simply unsustainable. What has actually happened in this case is that after my clients obtained leave to appeal, conscious risk-taking having not been mentioned at all in the short submissions in response, a long skeleton argument was put in by the Weiss expanded legal team, which took this point for the very first time. And we cried foul in correspondence, said, where is your respondent's notice? This was not how the case was decided. And that's the reality of this point. This case, on mistake, will always turn, and has always turned, on whether the judge applied the unconscionability test correctly. That was the basis upon which fundamentally leave to appeal was granted. And the reason why it is an arguable appeal, and the reason why it's an appeal which should be allowed, is that we have to ask ourselves what the equities were between Terrell and James, not what the equities were between Terrell and Christina. That is the mistake which allowed this case to go wrong in the first place. And the fact that the judge, as it were, did not see, and it's completely understandable on a human level why he didn't, the analogy to be drawn between what happened in Pittenholt and what happened in this case. I own to a mistake, monies are gifted to a donee, that donee is liable to a third party, it's that liability to a third party which is repugnant to the donor and was the subject matter of the mistake, and then subject to that liability, notwithstanding that liability, all of the gifts should come back. Because the donee is a volunteer recipient, it is unconscionable for him to retain the gift. And when one looks at the analysis with that degree of purity, it is the right answer. I cannot do anything about the fact that the judge made the findings he did about my client's evidence on the non-disclosure issue. But all I would say is that fundamentally did not go to the equity upon which she sued. Now, my lords, I don't propose to say much more than that, save to respond to the point on Baur, which was a case, incidentally, that we put in the bundle. That was in our skeleton argument. We weren't hiding that case or shying from it. That's the artificial tax avoidance case. But in that case, the payment itself was part of a dishonest scheme. And the way in which my learned friend tried to make Baur analogous to this case is that he said, well, there were two conspiracies here. Conspiracy number one was in 2022, and conspiracy number two was in 2023. And the reason why he's wrong about conspiracy number one is that there is nothing fundamentally unconscionable or wrong or deserving of a public policy exclusion in a mother-in-law wishing to make a gift to a family member and then refraining from doing so because she fears that it will expose her son to a matrimonial claim. There is nothing wrong in her doing that. It may be that there was something wrong there was something wrong, I can't shy from it, in James not having disclosed the fact that he knew the gift was coming. But it was Terrell's money. She can give it to whomever she pleases, or not, as the case may be, and based upon whatever the circumstances might be that motivate her at a given time. As I said before, this was not a forced heirship jurisdiction. There was no reason for her to feel guilty about not giving money, about refraining from giving money when she thought her daughter could bring a claim against it, and then making a gift when she thought her daughter could not. So without wanting to detain the court any further...
It's a time matter for you. I don't think we have any questions.
Thank you very much, my lords and my lady.
Thank you. Thank you all very much for your comprehensive submissions that I'm sure a considerable number of people have contributed to. We will be providing our drafts for the usual limited purposes, I'm stressing. In other words, not to be distributed further than allowed, and simply for the purposes of correcting grammar and typos and typographical errors. And we would assume that once you've received our judgments, you will be able to agree a draft order, but if not, we will deal with any outstanding matters on paper. So thank you again.
Court rise if able.